Peter Obi don again tell supporters say there was never a time when he tell them say the road go dey easy. There was never a time when he promise them say he go just enter fion like that. He say he don fit dey tell una right from time say the journey e no dey easy. Say e go dey painful. Say e go dey difficult. He say but make una no fear. Make una no dey sorrowful. Make una no dey regretful. Say one day e go be. My people, at this one come still bolofo, I come dey hear say the tribunal thing wey the judgment wey they give, say the paper wey they read, e carry Tinubu legal team watermark. Wetin this one mean say Tinubu legal team name dey the paper as if say na dem na im write am, then they pay put, then give the judge make they read am. The thing I come blow internet to everywhere, come scatter. Hey, people come they say, they talk am ra. The thing be like fin for everybody. The thing fear person. Say see wetin they ought to take wine Nigeria. They all wine us, they play us, and they play football. My people, Nigeria, it is well. As this one come still bolofo. Now so come they hear say the wife of Bauchi governor Aisha Bala Mohammed convoy come dey trap for inside bad road within the state, to the extent she herself and the convoy they were forced to come down from their car, come use leg take cross road, take pass inside mud water. Hey, my people, everybody go collect oh. Lastly, now this news now bring comfort now. Who can they hear back? It got be like say me these two people with the say the interview, may they begin to fear. Here not be here. In fact, this tribunal matter it costs many wahala for all parties. Make I let the video play. Make una watch my people on Bod TV. But don't forget to like, share, and subscribe. Make una also comment, make una like, una do well, my lovely people. Wakoyo, wadomo.
Two lawyers and prominent commentators on national issues, Chris Wakobia and Leberus Oshoma. It's good to have you on the show, gentlemen. Let's go straight into it. We have little time. Now, we're looking at this unanimous decision of the Presidential Election Tribunal court affirming President Bola Ahmed Tinubu's election as the president of Nigeria. Now, in your opinion, what is the significance of such a unanimous verdict in such a high-profile case, and how it might affect the public perception of the judiciary, and of course your thoughts on the judgment as a whole? We'll start with you, Mr. Chris.
Good morning, Shay. Good morning, Akeredu. Let me say clearly here that your question captures the mood of the nation. Your question captures the sentiments. Your question captures the perception of the people due to what happened on the September the 6th, 2023. And I say this advisedly. Maybe Mother Providence had its own predilection, permit my choice of word, when the judgment was fixed for the 6th. In metaphysics, 6 is the number of man. Man has his own tendencies to disappoint, if you like, his frailty. And in this case, not wanting to stand by and for the truth, and interestingly, I hope that when the matter gets to the Supreme Court won't choose another 6th, number 6, to disappoint the people, because the issues are very lucid. They are fundamental issues, and in law, we're taught as young students in law school that judges do not descend to the arena. They don't grant prayers you do not ask for. And let me say clearly that in one of those very funny paragraphs in the judgment, the judges came down to the arena. They did say about a certain witness from the Labour Party that she was a party member, the lady from Amazon, that they cannot admit her evidence because she's a member of the Labour Party. and then turns, on the other hand, to admit the evidence from a sitting senator, from a member, a reputable member of the APC, my brother and friend, who is presently the majority leader of the Senate, Bamidele Okpeyemi. That's, on the one hand, admitting that clearly, if you like, maybe it was the voice of Esau and the hands of Jacob, or vice versa. But let me say clearly, as I talked to you this morning, what is important is that, like we said before the judgment, all eyes were on the judiciary. It was the judiciary that was on trial. We have seen the certified true copy of that judgment, and clearly on the top of it, the header. I don't know why they made that mistake. The judgment, as it were, assumedly proceeded from the APC presidential legal team. And you could see when the judges were reading it, they were not reading a judgment that was indigenous to them. They were not reading a judgment that they could own. They were, if you're reading your speech, you make very little mistakes. But when you're reading a prepared speech, a written speech, of course you could see it. Everybody who watched that, the longest, if you like, the longest judgment we've seen in our historicity, would understand that it was clearly about the puppet and the puppeteer. But I believe that what we're doing, this forensic, is actually interested in putting our democracy right, because congruent with democratic process is the transparency and the credibility of the electoral process.
All right, let me turn my attention to Liberals. And I would say, like Mr. Walker just mentioned, the judiciary was on trial. And what can our institutions do to restore confidence? And that is one question. Do not laugh. That is one question. The other question is this. Let's put it into perspective. Between 1999 and date, myriads of issues have come before the tribunal. Be it in Obasanjo's case, whereby they said he belonged, accusations were made by Olufalaye that he belonged to a particular secret organization, and some other issues that we've seen from Buhari and the rest of them, Atiku. We've never seen the tribunal overturning election results. Why is that so?
Thank you. Before I go into your question directly, I would want to quickly address the issues raised by my friend and brother here, Chris Wokobia. As a practicing lawyer that have handled election petition matters since 2003, I will not sit down here and allow a fellow lawyer claim that a judge reading a judgment and with one or two corrections in court, that judgment does not belong to him. I do not know if Chris had listened or handled matters where judges will read judgment for 5 hours. I have. I also know, as a lawyer that handles election petition matters, that election petitions are not dealt with on the basis of sentiment, but on the basis of pleadings. Also, I will also say this, that everything the Court of Appeal said on the 6th on Wednesday is not novel to me, and is not novel to a lot of practitioners that have been involved in election petition. And like you rightly mentioned, the Court of Appeal and the Supreme Court in myriad of cases have said so much. So let us leave out sentiment from all of this and address as lawyers and look at the issues. Lastly, on the issues he raised, the courts, I've been reading the judgment, because even after listening to it, and I still take my time to read the entire gamut of the judgment, because what most lawyers do, they analyze judgment on the basis of newspaper reportage. We analyze judgment on the basis of law reporting. The court did not admit the testimony of the woman not on the basis of the fact that she's a party member, but on the basis of the fact that she's coming as an expert witness that is coming to speak to a document that she did not produce as an expert. So let us quickly lay the issues, because I would also, if I expected him to even take me to the area where the court specifically mentioned her because she's a party member. That said, election petition, why has the court not been able to upturn presidential election petition? Presidential election petition generally, like we say, are sui generis, and your petition will rise and fall with your pleadings. There are also, with the restrictions of 180 days and the new amendment to the Electoral Act, even amendment of petitions are no longer allowed, and it is also sacrosanct that petitions must be filed with witness deposition. Once a petition is filed and witness deposition are subsequently front-loaded, be rest assured that those witness deposition will be discountenanced in the course of the hearing. Also, because of the requirement for presumption of regularity in favor of INEC once results are announced, as clearly stated in the Evidence Act, once you, just like section 36.5 of the 1999 Constitution, the onus is now on he who asserts to prove that indeed this presumption should be shifted. And how do you prove? It must be through witnesses that were present at the polling unit, not people who were told what happened at the polling unit. And also it must be through documents that were handed over to you at the polling unit. You are bound by time. Why file a petition knowing fully whether you cannot amend? Why file a petition and now wait for INEC to give you documents that you will now in turn file later, knowing fully well that the same document will be discountenanced at the trial? So I think the law, the requirement of the law on proof is so high that it is difficult to disprove between, the specific time. That's why you have all of those challenges.
Right. I would like to, really back in, and I want you to respond to that, because these are very serious allegations that you've put forward, Mr. Wakobia. So can you respond to that, and then we'll go to the next question?
Very strongly, let me say that in law, my brothers just talked about how one of the most profound election petition lawyer in this country is a lawyer that represented the Labour Party. And then Chris Uche. So we have different sides to these issues. But let me say clearly here that the questions I'll put here. One, if you talk about the proof, the presumption of regularity in favor of INEC, what did INEC say before the elections, and what did he do during the elections? And what happened, what the justices, because if you follow the entire ruling, you find out first that at every point in dismissing the issues put before the court, the justices descended to the arena. They sounded like litigants. They sounded like they were defending the position of the All People Progressive Congress. And I say, you saw the issue about 25% of Abuja. Rather than staying on the provisions of Section 134 and Section 299, they were simply pondering around the issues. By law, the Constitution provides a special status for Abuja. They threw it away. Regarding issues about, and I'm saying this without fear of querulous criticism, regarding issues about forfeiture, interestingly, that's why I said maybe metaphysically, the justices of the Court of Appeal were meant to make the mistakes like human beings, because the Supreme Court were going to face the Chief Justice of the Federation, who had, in a previous ruling in 2014, 2007, and 2014, admitted that forfeiture is a penalty for a crime, and then if it's in the event of a civil offense, it, according to the Constitution of the Federal Republic of Nigeria, can pass to vitiate the candidacy of anybody seeking the office of president. They didn't address the fundamental issues there. They just pandered around it. And then what about the issues of double nomination? For a judge to say that Shetima's was inadvertent, that his double nomination was not deliberate, that was descending to the arena. Everything about that judgment, everything, and that's exactly why the candidate of the PDP said in no uncertain terms that what we had on the 6th of September was judgment, not justice. And then the candidate of the Labour Party said in no uncertain terms that we're going to the Supreme Court to address these fundamental issues. You don't sit down and say that because nobody has been removed by the court of law in a presidential petition, that it cannot happen. What we're talking about is justice. What we're talking about is doing what is proper, right, and right. I do not think that insisting that the law should be followed strictly is pandering to emotions or sentiments.
All right, Mr.
The law is a law, and if you must follow the law, do so and interpret the Constitution and the Electoral Act. You don't do a 12 hours judgment ruling that is basically pandering to the whims and the caprices of the ruling party. You don't do that.
I would like to come in, so sorry, Aaron, I would like to come in here because, fine, we've spoken about the judgment, but I also want to talk about the blunders because we have 21 days, of course, for them to refile and go to the Supreme Court with the same evidence and with what the judges were able to look at during this presidential election tribunal. And the court noted procedural blunders by the petitioners' legal teams, including failure to file witness statements on oath as required. The court also highlighted paragraphs of the petitions that were deemed vague and imprecise or generic. They also emphasized the lack of credible evidence presented by the petitioners and seeing how these errors impacted the outcome of the case. We're looking at the back end where some senior lawyers have said that the justices did a thorough job to the extent that the representing parties were chided even while the judgment was being read for the inadequacies in their research to build their clients' cases. Now, are we looking at a situation where the opposition's petition was watery from the beginning because what the judgment was based on the facts that they were able to look at? And if they're using that same those same witnesses and that same all of that, taking that to the Supreme Court.
You don't sacrifice justice on the altar of technicalities, Chaito. You don't sacrifice, I'm coming. You don't sacrifice justice on the altar of technicalities, Chaito. And that was why the judges did.
Okay, can we, gentlemen, if we can just take it one point at a time. All right then, let's go to Liberals.
Yeah, so let me first and foremost say that my friend and brother here is not talking love or sentiment, really. With all due respect to him. The judges, thank God everybody listened to those judgments. For the discerning, like you have rightly identified, the judges pointed at, how do you read judgment? You will read the argument in the body of the pleadings, the facts in the body of the pleadings. You will bring out the argument in support of those pleadings. Then you read the pleadings in contradicting those averments in the petition, that's the averment of the respondent. And then you read also the argument in support, and then you draw a conclusion as laid down by the laws, not sentiment. So what we have here is a situation where, first and foremost, you say the lawyers that handled the matter, yes, we agree they are seasoned lawyers. The lawyers for the respondent also are seasoned lawyers. Lawyers, no matter how seasoned, one person must, at the end of the day, will win. So in this case, what transpired? What happened? Let's look at the averment one after the other, because I want to discuss law. I don't want to discuss sentiment. I don't want to talk about morals. you allege that you have agents in 170-something thousand polling units. You couldn't produce one to disprove or to prove the evidence that truly there were irregularity in at least one polling unit. On the issue of 25%, in 2005, the Court of Appeal and the Supreme Court in Obasanjo, if not for time, I would go straight to the dictum of the Kitobi GSC. If you permit me, I can read it for you. Held that there are no special status in as far as votes are concerned, and that all votes are equal. The Court of Appeal on Wednesday simply followed that dictum that had been laid down. And Section 299 of the Constitution also states that for the purpose of this Constitution, FCT shall be taken as a state. Allow me, please. And so, what the court simply did was to reiterate the position that had been stated by law. And so, if you are going to counter those positions, you must cite a superior law and not come here and pander to sentiment
at this point
and begin
in time,
to call
before we come
names
to Mr.
and
Walker
say
here,
those judgments were written.
Permit me to interject at this point, because if you're speaking about the law, people were a little bit perplexed and puzzled in regards to the five-man panel led by Justice Imani and sections 52 and 65 of the Electoral Act, which granted INEC the freedom to prescribe the method of transmitting results. And you and I know there is no secret. There are video evidences everywhere where INEC vowed and insisted that electronic transmission of results is the only way out. And they decided to renege on their promises.
Okay. So quickly, please, because I wanted to address that area.
Okay.
When a provision of the law gives a discretion and somebody says, I am going to do it this way, on the day of that election, that same person comes to say, for the reason of force majeure, I can no longer do it that way. I will do it this other way. What the court would do, the court cannot take away that discretion because it is not a discretion donated by the court, but by the law. And what the court simply said is this unanimously, both the Supreme Court has said this, the Federal High Court has said this, the Court of Appeal has said this repeatedly. What the court simply said is INEC has the discretion. The word didn't say shall. They said as stated by INEC. So if INEC gave a regulation and they are not able to comply with that regulation, does the law permit them that discretion? The answer is yes. That is what the law simply said. And then lastly on this, do you know that the same issue that we are talking about now, the Supreme Court, in the case of Oshun, when the Supreme Court delivered judgment, those that are complaining today, we are celebrating. On the same IREV, the Supreme Court, not Court of Appeal now, the Supreme Court said that INEC has a discretion. The PDP celebrated it and they said it was victory for democracy. APC complained that it shouldn't be. But today, it is in favor of APC. The same PDP that celebrated before are complaining. The APC that were complaining before are today celebrating. That is the law. It does not pander to sentiment.
Let me say very importantly that my brother here talked about the status of Abuja. Section 299.
Go to IREV.
No,
the Supreme Court judgment on
Section 299 on the status of Abuja talks about Abuja.
We are not
presumed.
Just go to
Can I just talks about Abuja clearly being presumed as a state on 3 accounts, not with respect to elections. Every state has its provision regarding elections.
Please.
Every state has its provision regarding elections. And you do not lump Abuja. Abuja does not have 3 senators. Abuja has 1 senator. Abuja does not have a governor. Abuja has a minister over Abuja. Abuja does not have a state cabinet. Abuja has a development authority. Abuja, by constitution, by the Constitution is unique and special. And those who live in Abuja are not necessarily settlers. You have indigenes and you have people from different places. So for those who, if you read, no, listen, I'm talking, I'll let you talk. The fundamental issues is that when people decide, and it was Sir Walter Scott who said, oh, what a tangled web we weave when first we practice to deceive. When we look at these issues, you don't sacrifice justice on the altar of technicalities. And that's the fundamental argument that I'm making here. If you wake up and tell me that regarding forfeiture, for instance, the present CJN of the country had ruled, and why didn't the court mention that ruling where he admitted in that case, Mohammed Abacha against the Federal Republic of Nigeria, he talked about forfeiture clearly as a punishment for an offense, or even in civil matters. Our Constitution in Section 137, subsection 1, talks about when you have forfeiture, either for criminal or civil offense, you lack the constitutional right to run for the office of president. So I don't understand where people get the validity for a judgment that is absolutely against the intent of the law, absolutely political, absolutely patronizing of the ruling party. But I say this to you clearly, and to Nigerians, that we will continue to test this whole, because ultimately what is important is that the man who must occupy the seat of power must not only be honorable, but must be seen to have won fair and square and according to the provisions of the law. What happened clearly without equivocation on the 6th of September was miscarriage of justice. It was judgment read to suit the puppeteer by the 5 puppets of the court.
Quickly, I do not, like I said, I want to discuss law. I don't want to discuss sentiment. Section 137, sub 1 says a person shall not be qualified for the election to the office of the president if he is under a sentence of death imposed by a court of competent jurisdiction, a competent law or tribunal in Nigeria, or a sentence of imprisonment or fine for any offense involving, let me finish. Fine for any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed on him by any court or tribunal, or submitted by a competent authority for any other sentence imposed on him by such a court or tribunal. And within a period of not less than 10 years before the date of the election to the office, he has been convicted and sentenced for an offense involving dishonesty, or has been found guilty of fraud or contravention of the code of conduct. Then if you go to section 299, I will take the two of them together because of the time. Section 299 says, because you cannot be reading into election petitions cases what is not there.
Read the dictum of Ariwola.
I would have to interject.
Section 299 says that for the purpose, quickly permit me, that for the purpose of this constitution, in interpreting this constitution, so look, the provisions of this constitution shall apply. The word shall apply to the Federal Capital Territory, Abuja, as if it were, shall apply, as if it were one of the states of the Federation
All right then, Mr. Libros, unfortunately, because of time, Mr. Libros and Mr. Chris Nwakobia, maybe we're going to have another conversation like this.
On which you can apply.
Mr. Libros and Mr. Chris, we have run out of time, but I can see how passionate you have both been about this conversation. But we have to go on a break.
This is Bod TV Bod. In case the first time you come here, please don't forget to subscribe and hit that notification bell for more uploads.